Welcome to this discussion on the United States Supreme Court and its nomination process. This event is being sponsored by the American Democracy Project, the Mike Down Center for Indiana Politics, and IPFW. A special thank you to the Helmke Library for allowing us to use this space, and to College Access Channel 56 for recording and broadcasting this discussion. I want to start by introducing the panelists. To my right is James Haw. Jim is a professor in the Department of History here at IPFW. This semester he's teaching the senior seminar course and has chosen as the topic the Constitutional Convention of 1787. He also has written a biography on John Rutledge, who was one of the original Supreme Court justices. To his right is Georgia Wralstad Ulmschneider. Georgia is a professor in the Department of Political Science here at IPFW. She teaches courses on constitutional law and the Supreme Court. Recently, she published 2 articles in the Encyclopedia of the Supreme Court. She also serves as the pre-law advisor here on the IPFW campus. And then finally, at the other end of the table is Steve Jackson. Steve is an attorney with the law firm of Baker Daniels, and Steve has been named to both the Best Lawyers in America and the Indiana Super Lawyers lists. These designations are based on blind peer ratings and are limited to the top 5% of all rated attorneys. He's also petitioned 4 times for cases to go before the U.S. Supreme Court. My name is Andy Downs. I'm the director of the Mike Down Center for Indiana Politics and the campus coordinator for the American Democracy Project here on the IPFW campus. I'll be the moderator for this discussion. We'll start with some general questions and background questions for the panelists, and then eventually we'll open the floor up to questions from the audience. Our first question will actually go to Georgia, and if you would, Georgia, just give us a quick step-by-step explanation of what the nomination process is right now.
Okay, in terms of the nomination process itself, it's of course the president who's actually the nominator, but it's a rather bureaucratic process. There is a staff consisting of people from the Office of Legal Counsel in the White House, plus staff members from the Attorney General's office that put together a list of prospective nominees who kind of vet them, make suggestions to, in this case, President Bush. He, out of that list, then selects a candidate. When that selection is made and it's kind of announced to the public, the American Bar Association has a committee called the Committee on the Federal Judiciary, and its job is really to rate the candidate in terms of professional qualifications. They either rate that person well qualified, qualified, or not qualified. The FBI also vets the candidate for, if you will, skeletons in the closet. Interest groups then go ahead, look at the candidate's track record and background, see how that person lines up in terms of their interests, and then the nomination is forwarded to the Senate, where, as you see today, the Senate Judiciary Committee is the committee in the Senate that's going to hold hearings and make a recommendation to the full Senate on whether the Senate should approve or not approve the nomination.
Very good. Thank you, Georgia. Now, Jim, is this the same process that has been used since the Constitution was ratified?
No, the original process was radically different and much, much simpler. The Supreme Court was constituted under the Judiciary Act of 1789, originally, which specified that there should be 6 judges. President Washington signed the Judiciary Act into law on September 24th, 1789. He submitted his 6 nominees for the original Supreme Court to the Senate on the same day, September 24th, 1789, and the Senate confirmed all 6 2 days later, September 26th. There were no hearings, there were no committees. The nomination simply went right to the full Senate, and after whatever discussion they wanted, they voted. Basically, the process stayed that way through the early years of the Republic, and even though it became hard in the 1790s to find qualified people who were willing to sit on the Supreme Court, oddly enough, and the quality of the nominees proportionally went down a bit. Case in point, Samuel Chase, nominated by Washington in 1796, ran into some grumbling in the Senate and outside the Senate because he had been accused of ethical violations some 20 years earlier as a member of Congress. Despite those grumblings, he was confirmed the day after the nomination was submitted. So it was a much simpler and a much more rapid process in the early years of the Republic.
So how did the senators make their decision? How did they evaluate the candidates? Obviously now they have the hearings to watch and listen to. Back then they didn't have that advantage.
They certainly didn't. I think that to a much greater extent than today, Politics at the leadership level was a kind of gentleman's club with limited membership, in which members of the Senate were likely to know personally or know by reputation most of the people nominated in the early republic. I suspect if there was someone they didn't know, they simply made inquiries of friends or contacts, perhaps senators, congressmen from the nominee state, or someone else who would know something about that person.
So much less show than we do have today. What did the framers have in mind for the qualifications of a Supreme Court justice? Since you mentioned that the quality fell off sort of after a few years.
Okay, the surviving records of the Constitutional Convention indicated that the convention did not address that issue directly and specifically. We can, however, get some idea of what the founders were looking for by comments that were made while they were discussing other issues related to the court, and especially the issue of who should choose members of the court. Should it be the Senate alone, the President alone, the Senate with the advice or the President with the advice and consent of the Senate, or some other procedure? George Mason, for example, stated that if the President alone chose Supreme Court justices, he might form attachments at the national capital that would deprive equal merit elsewhere of an equal chance for promotion. Nathaniel Gorham of Massachusetts said, on the contrary, the executive will be careful to look through all the states for proper characters. And James Madison agreed that the executive would in general be more capable and likely to select fit characters than the legislature. Well, there's the kind of dialogue that went on. The Senate was hoping to nominate people of merit, proper character, fit character, whatever that meant. In the context of 18th century political theory, I think they were looking for qualities like wisdom, experience, dedication to the common good, and what we would call merit principles. There was also, though, concern expressed by several delegates that merit be geographically distributed among the states so that each region of the country had its proper say. Sherman of Connecticut said that merit ought to be diffused in judicial nominations. And Madison expressed concern that if the Senate alone chose judges, the North would have a majority in the Senate and might ignore Southern candidates. The delegates also made some comments on what they did not want to see in choosing Supreme Court justices, in arguing for one method of selection or the other. Madison, for example, warned of the danger of intrigue and partiality. Gorham said if the Senate alone had the choice, the Senate would give full sway to intrigue and cabal. Randolph of Virginia said that legislative appointment often was determined by cabal or personal regard, while Ellsworth of Connecticut countered that if the President alone selected the President he thought would be more open to caresses and intrigues than would a plural body by the Senate. The record then, I suggest, suggests that the framers hoped for a method of selection that would produce the most meritorious, the most fit characters, free from any considerations of intrigue, political partiality, friendship, or the very factors that generally have affected Supreme Court nominees through most of our history.
Thank you. Steve, as someone who has petitioned for cases to go before the Supreme Court, what do you look for in a justice?
Three things, I think. Brilliance is at the top of my list. The United States Supreme Court is entrusted with deciding some of the most complicated, both complicated legally, but complicated in terms of policy-wise issues, and I don't ever want to have an argument before the court where I think one or more of the justices doesn't get it. That would be a disaster. Secondly, as Jim said, whether you call it merit, whether you call it impartiality, I want a justice who will decide the case based on the facts before him or her, the law before him or her, and the policy issues of this case, not one with a preconceived notion about this issue or that issue, not a case that's already been decided in that justice's mind. I can't think of a worse position to be in as an advocate than to think that you're going to have a fair shot, a fair argument, and my client's case will rise or fall on the merits and on the law, and to think that I'm in front of somebody who has a predisposition to decide this case one way or another based on something that's not before them, something that's not the law. That would be a disaster. And then finally, I am very interested in someone who's not only brilliant, but I think well-rounded. At the Supreme Court level, you're talking about law, but you're talking about policy, you're talking about judgment, and if you're going to talk about the American Constitution, I want someone who's read Locke, who's read Hume, who's read Rousseau, who, when we're talking about a social compact and a social contract and the things that the framers knew about and intended in the Constitution, that those echoes speak to the justices, that when the framers of the United States Constitution wrote it, they, in my judgment, wrote it believing that everyone who read it would have read Rousseau, would have read Locke, would have read Hume, would have understood the kinds of things that they were talking about there. So I want someone who's well-rounded in their education as well. Brilliance alone is not enough if that brilliance is very compartmentalized and doesn't translate into the broader understanding of things like separation of powers. What's the role of the legislature? What's the role of the judiciary? What's the role of the administrative branch? I want someone who understands, is well-read, and is well-grounded in those. Then, if my argument's meritorious, I have a chance of winning. That's all a litigant can ever ask for, is a fair shot to win.
Thank you. Georgia, we've now heard what the framers were maybe looking for. We've heard what a practicing attorney would be looking for. What is a president looking for when nominating someone to the court?
I suppose the first thing is a person that can be confirmed. And that has to do with a lot of things. That has to do with the timing of the vacancy and the chances for confirmation. For instance, a president during his last year in office, only 2/3 of his nominees have been confirmed. So you take these kinds of things into account. You look at the attributes of the justice that you're going to replace. Like, for instance, with Rehnquist, to try to get an easier confirmation, you want to replace a conservative with a conservative, as opposed to replacing a moderate or a liberal with a conservative. That's harder. Beyond being able to get that person confirmed, it depends upon the goals of a president in terms of what they want. Presidents vary. Some presidents, their number one goal is an ideological goal. And virtually every president has that as one of the goals. It's whether it's his or her highest goal. But does the ideology of the justice match the president's general ideology? Second of all, you're looking for, I guess, what I would say, professional qualifications, some of the things that Steve or Jim mentioned, but also other things. You're looking for experiences that individual may have had depending upon their position on the court. Do you want to judge, for instance, a person that has heard a lot of cases at the appellate level? Or perhaps, if you're looking for a Chief Justice, depending on the situation, maybe a judge isn't your first choice. Maybe your first choice is someone who's been more involved in other aspects of politics, that is used to compromise, gathering coalitions. You might want someone, as Eisenhower chose, like an Earl Warren, that could bring a court together that was badly kind of fractured. The third thing, sometimes presidents are looking for, I guess, what you would call representational goals. In the case of Ronald Reagan, for instance, he who was seen as anti-woman wanted the world to know he wasn't. So it was very important to him to appoint the first woman justice on the United States Supreme Court, Sandra Day O'Connor. Sometimes it's a personal goal. You want to reward loyalty. You want to reward kind of like service, etc., things like that. That's something that President Truman did a lot. He tended to appoint his friends. He felt comfortable with his friends. And lastly, sometimes a goal could be a partisan goal. Kind of, rather than a long-term ideological goal, a short-term goal, where you want to hold your political support or increase your political support. Like, for instance, Richard Nixon, when he appointed, for instance, Lewis Powell, was looking at a Southern strategy. So when he ran for his second term, he was hoping to gain more votes out of the South. Whether people actually vote on the basis of a Supreme Court justice is a whole nother matter. But all those things go in the mix, and it really varies by the president, what his goals are, what combination, and of course, you always want the person confirmed.
Perhaps the number one goal there.
Yeah.
Well, Georgia, Gallup recently published a poll that showed that 47% of its respondents felt that this nomination, John Roberts' nomination, mattered a moderate amount or a great deal to them. And 47% might seem like a low percentage to some people. Is this statistic troubling to you?
No, it's not troubling at all. In fact, I think it's a great statistic, kind of compared to the past. There's been all kinds of polls regarding what the American public knows about the Supreme Court. About 5 years ago, there was a poll suggesting that 59% of the American public knew the Three Stooges, but it was only 19% of the American public that could name 3 Supreme Court justices. And there are like other examples as well of Anthony Kennedy kind of coming out of the court and an individual saying to Justice Kennedy, could you take my picture in front of the United States Supreme Court? Or John Paul Stevens coming out and a tourist who was very interested in the court, why would they be there if they weren't, going, could you get out of my way? I can't get a picture of the court. Or probably the greatest example is, many of you might know, that Harry Blackmun was the author of Roe versus Wade, a decision, of course, the abortion decision, very famous, very controversial. And in the 1980s, Harry Blackmun used to stand outside the court, watch the anti-abortion protest, and not a single person knew who he was. So 46% feels pretty good, Andy.
Steve, you nodded along with it.
I'm inclined to agree. I mean, I think if you took the American public last night and asked what percentage watched Monday Night Football and what percentage watched the confirmation hearings, I don't think it was 49%. I would be amazed if 49% of the respondents could name anyone on the United States Supreme Court. It is an institution, and Supreme Court justices have said this before. They don't have an army. They don't have a police force. They rule only because the American public holds that institution in high enough esteem that when 5 out of the 9 of them say this is the law, people follow that law. And so having a low profile is not necessarily all that bad for that institution. It derives its power by the common deference and respect that we as citizens have for it. And so I don't think we need any rock stars on the Supreme Court. It's not my idea of a good thing.
Jim, should this matter more to the public?
Idealistically, I believe it should. Realistically, of course, people are occupied in a variety of concerns other than paying attention to politics. We all know that. But we are in an era when the Supreme Court is deciding many, many cases that are very, very important to the American people, and when it is issuing a lot of very controversial decisions that tend to polarize the country. And consequently, I think there is a lot to be said for the proposition that people should be very interested. I mean, the court is the last word on a lot of major issues that people care deeply about.
Well, one of the things that's been discussed with nominee Roberts is whether he should answer questions about specific issues such as abortion and affirmative action, or whether he should stick to answering questions only that get at his judicial philosophy. If you would, Steve, start by explaining what someone might mean by the expression judicial philosophy.
Okay, Andy. A judge's judicial philosophy is his or her overarching view of the role of the court as it relates to the other branches of government, the legislature and the administrative branch, and his or her view of how the court interacts with that. These things tend to have names for them like liberal and conservative, which aren't very useful because they tend to run into each other. But the best example would be is as a matter of philosophy, not as a specific case, does Justice Roberts believe that when Congress passes laws, they're entitled to tremendous deference because they're the legislative branch and elected by the people, or very little deference? And if the Supreme Court thinks they simply got it wrong, the Supreme Court should say, you got it wrong, try again. That's a very simplistic something that there's an entire course or two about in law school, so in 35 seconds, that's it. But we're looking for an overarching approach to being a judge. How do you approach that? What's your philosophy that's applicable across a broad spectrum of cases, not any one particular case? And if you happen to listen to any of the confirmation hearings yesterday or today, John Roberts talked a lot about his philosophy, about judges obey the law, they don't make the law. You know, that's his philosophy and approach. Judges serve people, they don't tell people what to do. The Supreme Court serves the country. It serves Congress, it serves other branches. So, again, that's an imprecise and short, but that's what judicial philosophy is all about.
That same Gallup poll I mentioned earlier showed that 55% of the respondents felt that Roberts should be responding to specific issues, while only 40 or 42% thought that he should stick to judicial philosophy. Georgia, under what circumstances do you think that a president would want his nominee answering those specific questions, or under what circumstances would a nominee just functioning on his own want to answer those questions?
I think the circumstances are more likely that a president doesn't want his nominee answering specific questions, and a nominee probably doesn't want to, in part because, for a couple reasons. One, the kind of general argument, and Steve brought this up earlier, the whole notion that when you start answering specific questions, you get in that fuzzy field, has this person prejudged a case? And will they be open and impartial when a case that includes those issues comes to the Supreme Court, which is kind of a larger ethical issue. On kind of a small p political issue, one of the things you don't want as a president and a nominee doesn't want is, of course, to open himself or herself up in terms of ammo. The minute you start discussing specific past cases, it's far easier for your opposition, if you will, to be able to use you as target practice. And so there's a lot of reasons, both ethically and kind of pragmatically, why you generally don't see nominees want to ask answer specific questions, and you don't want to see a president necessarily urge them to. The exception I can think of is if it's an issue where there is a broad consensus among the American public and even across party that will just engender generalized support for that nominee. For instance, if a nominee was asked, do you support the Supreme Court's decision in Brown versus the Board of Education, which is the famous decision that, of course, said separate but equal is unconstitutional, I think very few nominees and very few presidents would flinch from allowing a nominee to say, yes, I think that's a great decision, I think that's good law, all those kinds of things. So you get that kind of pragmatic situation.
Well, Steve, as a practicing attorney, would you like to hear specific answers so you might get a feel for where some bias might lie? I mean, there is a sort of a pragmatic reason for you to hear that.
Actually, I wouldn't. I'd be appalled at any nominee who answered a specific question. There are really a couple of reasons. For those of you who brushed up on your Constitution lately, if you look at Article 3, Article 3 has what's called a case or controversy requirement in it, which says that the federal judiciary does not answer hypothetical questions, right? They don't give what are called advisory opinions. And if judges who are good judges are used to not answering hypothetical questions, I certainly don't want them answering them as a nominee to the Supreme Court. But on a more practical basis, we're all taught in law school cases turn on specific facts. If you change the facts, you're likely to change the outcome, and you can't ask a nominee a question, in my judgment, which is so encompassing of all the facts that you get a very fair answer there. So one thing, when I said before, I want a nominee whose mind is nimble, who can understand that if you change the facts or change the law or change the precedent, the previously correct answer may no longer be the right answer because of those changes. And so I'd hate to have someone who's staked out a position, I'm for this or I'm against that. I would lose an awful lot of faith in a nominee who did that.
Jim, historically, has there been any expectation leaning one direction or the other on this matter?
Well, no, I don't think judges historically have been expected to state their opinions on specific cases, past or present. First, as mentioned earlier, through most of the course of history, judicial nominees simply were not asked to testify before the Senate. It wasn't done until the 20th century, and it's my understanding that it wasn't done regularly until the 1950s. So the whole business of asking a judge to testify at all is of relatively recent origin. And I would agree with what my colleagues have said. A judge should not go into how he would rule on a future hypothetical case. In a way, I think that what we have here, simply asking the question, may be of an example of legislators in a legislative mentality asking questions that are more appropriate for the selection of a legislator than of a judge.
So of the whole number of nominees who've gone before or gone up for a vote, how many of them have not been confirmed? We're actually chatting about this a little bit beforehand.
I have those statistics. 150 in our country's history have been nominated. The Senate has rejected 12 on a straight up or down vote. The Senate voted to take no action on 5 nominees, which is the political way of saying we don't like you, but we really don't want to tell you. They voted to postpone votes 3 times, which again is a polite way of saying, we're not willing to say yes right now. If we put it off till next year, you can get the message. And a statistic that I thought was remarkable, 7 nominees declined the job. So you can see that, particularly back in the old days, a president, the late 18th, early 19th century, put a name in nomination without asking the nominee if he thought it was a good idea. The best example I saw of that is John Quincy Adams, later the President of the United States, was nominated to be Justice of the Supreme Court by James Madison. He said, I don't want the job. So, interesting history there.
Well, how should we, obviously, interpreting from the early 1800s to today, very different. Georgia today, if, for example, Roberts is not ratified, or how should we interpret that?
Well, there have been kind of ebbs and flow historically, if you kind of look overall. And I would add also to Steve's kind of list of kind of like turn downs, in other words, not being confirmed. Also those people that chose to withdraw their nomination after a certain point. If you add that list, what you get approximately, depending on the count, is about 1/5 to 1/6 of the nominees have not been confirmed, about 20% or a little less. Now, what's interesting about that is actually that is pretty significant statistically, because there have been far more, for instance, nominees to, let's say, cabinet positions. And if I read correctly, as of 2003, there were only 9 cabinet nominees that were not confirmed. So that's a rather high statistic. Now, ebb and flow, early on, and Jim can talk about this a little bit more, but most of the nominations made it in terms of not being turned down. Then between 1811 and 1894, it was kind of a much bigger rise in either withdrawal, no action, rejection, etc. And there's a lot of reasons for that. Some of it has to do with general political consensus or lack thereof in the country. For instance, the Civil War and the issues of the Civil War kind of informed the voting process, if you will. And there were some other things as well. The Supreme Court justices were expected to ride circuit, and a Supreme Court justice with 2 lower court judges made up kind of lower panels. And when that happened, geography played a part. And so if the right person wasn't nominated, in other words, it was not geographically correct, you could see a turn down. Then from 1894 to approximately 1968, again, very few defeats of nominees. Since 1968, I think political scientists generally are musing that there may be a rise again in terms of either withdrawals or defeats or filibustering, etc., as happened with Abe Fortas in 1968. So, and that may have something to do with a much more divided government in terms of parties. It may again have to do with a lack of consensus on big questions of the day, from separation of church and state to questions of abortion to all those kinds of things that Jim kind of mentioned earlier that should be relevant to people.
Jim, how many times has a Chief Justice been nominated and not approved?
I believe two. John Rutledge in 1795. Was it Fortas in the
Abe
Yes.
Fortas.
Yes.
Yeah.
60s? Yeah.
And
And in both of those cases, well, I can speak to the Rutledge case, I guess more directly, and it is a very, very curious situation. John Rutledge appeared at first glance to meet every criterion in terms of experience, brilliant lawyer, tremendous service to the country, member of the Constitutional Convention of 1787. President Washington nominated him for Chief Justice in 1795, and after Washington made the nomination, but apparently before Rutledge learned of the nomination, Rutledge made a very violent speech denouncing the Jay Treaty with England, which was a major policy initiative of the Washington administration, and he denounced it in the strongest terms. When word of that reached the Capitol, members of the Federalist Party who supported the treaty and the Washington administration were just aghast. And even worse in their eyes was where Rutledge made that speech. He made it before an angry crowd at a public protest meeting in the streets of Charleston. Now, this was a time when Federalists were very worried about the radical influence of the French Revolution, perhaps destabilizing government. The previous year, the Whiskey Rebellion had occurred in Pennsylvania, raising perhaps overwrought fears of anarchy. And Federalists began to say, oh my gosh, Rutledge is stirring up mobs to oppose law and order and the government itself. At the same time that word of this reached Washington, rather New York, the capital at the time, reports began to circulate that Rutledge was mentally deranged, drunk, and dishonest in paying his debts. There was a certain amount of truth to that. Washington did not know any of this at the time he made the nomination, obviously. But 3 years earlier, in 1792, Rutledge's wife had died suddenly, only weeks after his mother had died. Rutledge was deeply attached to both of them, and it was a terrible, terrible blow to him. In addition, Rutledge had lost virtually his entire fortune in the American Revolution and could not pay his debts. And thirdly, Rutledge was in poor health. He was declining physically, all of which had reduced John Rutledge to severe depression. And by all accounts, he did begin to act erratically. The odd thing about it is that as far as we can tell, even though he was terribly, terribly depressed, Rutledge was able to pull himself together enough to act very capably as Chief Justice of South Carolina throughout all of this attitude. So the rejection of the Rutledge nomination was based on a characteristic or a combination of those two factors: politically motivated horror at his Jay Treaty speech and the forum in which it was made, and the fear that Rutledge simply was not mentally capable of performing his duties. So the Senate turned him down by a vote of 14 to 10, and the odd thing about it is that 13 of the 14 senators of the president's party opposed Rutledge.
Wow.
Every member of the opposition party supported him. Now, if either of the two factors, the politically motivated opposition to the Jay Treaty or concern that Rutledge was not mentally fit for the job, if either one of those factors had been removed, Rutledge might have been confirmed. But, of course, that's speculation.
Sure. Well, we're at kind of a unique point right now in that John Roberts has been nominated not only to the Supreme Court but also to Chief Justice, and there is another opening on the court right now. Once again, as a practicing attorney, Steve, are you more interested in the Chief Justice appointment or more interested in finding out who the other nominee will be?
I'm much more interested in the Chief Justice position. When historians look at the Supreme Court, they generally refer to it over a period of years by the name of the Chief Justice. The Burger Court for Warren Burger, the Warren Court, the Rehnquist Court, and that is a shorthand way of reflecting the tremendous influence that the Chief Justice wields on the Supreme Court. The Chief Justice has the power when he, or maybe she someday, but is in the majority to assign who writes the opinion. That's a very, very important thing to do. The Chief Justice controls the discussions of a case after an oral argument's been made and all the briefs are filed and the justices gather and they start talking about a case. And the Chief Justice, a Chief Justice who is a consensus builder, as Georgia mentioned earlier, can sometimes forge consensus where one who's more of an ideologue may end up with a perpetually divided court. And I think it's fair to say that the Supreme Court's prestige as an institution is often enhanced when it decides matters 9-0 than when it decides them 5-4. The 5-4 decisions give the losing side hope that all we have to do is change one justice and maybe we'll win. Brown versus Board of Education that Georgia mentioned was 9-0. It left absolutely no doubt to anyone in this country that in the view of the United States Supreme Court, separate but equal violated the Constitution for minorities. That's the kind of judgment, in my view, that needed to be unanimous. The country needed to hear that there was no hope for segregation as a part of the philosophy of this country. Again, that's my own personal view. It's not the view of IPFW or anyone on the panel. I don't know what their view is. But from a practicing attorney's point of view, the Chief Justice is far more important.
Well, Georgia, has the Chief Justice typically had that sort of power and sway? I mean, does the Chief Justice really move the court in one direction or the other?
Again, I guess I would echo Steve's point. It really depends on part of the leadership skills of a Chief Justice. And there are a variety of leadership skills. There's what are called task leadership skills in terms of assigning the opinion itself. But I alluded to it a little bit earlier. There's something called social leadership skills, which have to do with consensus building. And it really can make a huge difference on the court. For instance, Warren Burger was not known to really move the court in the direction that was suspected he would be able to move it in by the person that nominated him, who was Richard Nixon, who was hoping for more law and order court, a court that might kind of moderate the views of the previous Warren court in areas of civil rights and freedom of expression, etc. And part of it is Warren was not particularly, not only a good task leader, he was not a very good social leader. Didn't have a lot of consensus. But that alone won't necessarily do it. I think most scholars that look at the court agree that in terms of social leadership, in a lot of ways, Rehnquist should be a good social leader. He's affable, he gets along and, if you will, plays well with others who do not agree with him, etc. But, of course, if you have ideologues on the court, say, for instance, someone like a Scalia, for instance, it is hard to move to consensus with an ideologue. So there's kind of a lot at play, but certainly a Chief Justice is capable of that kind.
It's just a question of whether they actually execute that,
whether
have the
they
skills to do
execute it, and whether the context is there to be able to execute it.
Jim, did the framers actually discuss what they expected out of a Chief Justice?
No. The proceedings of the Constitutional Convention are entirely silent on that. And I think the reason for that probably is that the framers did not want the Constitution to get bogged down in specifying minutiae and detail. So, for example, they don't write into the Constitution anything about congressional committees. They don't write into the Constitution the rules of the House, the rules of the Senate. And likewise, they don't write into the Constitution just exactly what the Chief Justice is supposed to do and how the court is supposed to function. Those institutions are free then to evolve their own precedents and their own traditions and to change them as circumstances may dictate without the necessity of trying to ram through a constitutional amendment for relatively minor details. So, no, they did not specify the role of the Chief Justice.
Yes, Steve.
They didn't, and that's one of the things I hope all of you take away tonight. If you watch the TV show and you hear some pundit or some self-appointed expert on one of the shows saying, well, if Roberts is confirmed, this will mean this or this will mean that, both Georgia and Jim know, presidents are regularly disappointed that they don't get out of their Chief Justice nominees what they thought they did. President Eisenhower often was heard to say that nominating Earl Warren to be the Chief Justice was the worst thing he ever did because he didn't get what he thought he was going to get. Richard Nixon didn't think what he thought he was going to get from Warren Burger. And so you can take anything that they tell you about if Roberts is confirmed, what that will mean and what Bush will get with a very liberal historical grain of salt, because history suggests that most of what they're probably going to tell you is probably wrong.
In part, that's due to the fact that presidents have multiple goals.
True.
If every president just picked on ideology, there's a greater chance you get it. But as I just said, there's multiple goals.
Sure.
So Eisenhower, in part, picked Warren because of what I suggested was personal loyalty. Warren helped him get elected president. So even though he was interested in ideology, that was as big a goal. So it shouldn't have come as that big of surprise because, because ideology was not the first goal. So people need to bear that in mind as well.
Well, I want to thank the three of you for being with us, and I want to open the floor now to questions from the audience. If you have a question, please raise your hand. We will repeat the question so that these fine microphones will pick up what your question is. So, questions?
If you think...
From the back, yes. Yes.
You're talking about the overarching philosophy, judicial philosophy. In his statements yesterday, Roberts referred to himself as the role of the umpire,
Yes.
the referee. I've been thinking about that ever since. I can't decide what I think of that. I would be interested to know what you think of that, whether you think that's an apt description or not. I'm not a politician, he said, I'm a referee. And I thought, either that's profound or naive, and I can't.
Well, it's certainly catchy. But
Steve, just let me repeat the question. if you
yes,
could.
the question was, during his initial statements to the United States Senate Judiciary Committee, nominee Roberts, in describing himself, said, my role as a judge is I'm the umpire, or I'm the referee. And I think, to answer your question, I think it's pretty profound and frankly spot on, because what he's trying to suggest is he doesn't have a stake in the outcome, right? The umpire doesn't care which baseball team wins. The umpire knows the rules. They're all in the rule book. The umpire applies the rules, hopefully dispassionately and equally to each team, and lets the merits of the performance of the competing teams decide who wins, as opposed to coming in and saying, yeah, I always hated the Yankees when I was growing up. I like the Indians, so my strike zone's going to be real narrow for Yankee pitchers and real wide for Indian pitchers. You don't want a judge who says, in a criminal case, the government's always right, if they wouldn't have been in court if they weren't guilty of something, and so the government always wins all the close calls. So I really like that analogy. I thought it really brought home to the country the proper role of a judge.
Georgia?
Kind of from the perspective of political science, I thought it was an interesting, I looked at it in terms of kind of capturing political rhetoric in trying to set the agenda vis-a-vis the committee. That if you were one who didn't want to be in the position pragmatically of answering specific questions about your views because you didn't want to give the opponents any ammo, so to speak, you didn't want to be a target, then if you capture the rhetoric and use the idea of the neutral umpire and kind of set the tone in the agenda, then it makes it harder for the people doing the questioning to be able to get at you, if you will. So I thought that was interesting from a pragmatic angle as well.
Jim, any comments?
I agree with what Steve said, and he said it better than I could have. I thought perhaps the analogy could be interpreted also as saying legislators are the players arguing out issues of policy. What I'm here for simply is to enforce the Constitution in a narrow sense. We will not determine issues of policy. We will simply apply the Constitution in a neutral fashion as we see it.
Thank you. Next question. Yes.
Is there any advantage to the court by nominating a Chief Justice that's already Associate Justice instead of having a nomination come from outside the court?
That's a good question. Is there any advantage to nominating a Chief Justice who is currently serving on the court, or is there, for that matter, an advantage for nominating someone who is not a Chief Justice on the court? Or an Associate Justice, excuse me.
Well, it's only been done 3 times. I mean, it is rare to nominate an individual who's already been on the court. Now, Steve may or Jim may speak to different advantages because we all kind of look at it a little bit differently. But if you're looking again at, can the person be confirmed from the standpoint of the president, the pragmatics of politics, if you will, sometimes it is not such a good idea to nominate someone who's already been an Associate Justice for the reasons I already suggested. You have a very long paper trail, which if the Senate is specifically is of the opposing party to the president, not good at all from that standpoint. Now, there may be other reasons why it would be good, but it's very rare. It's only been Rehnquist, Stone, and Hughes. And Hughes went off the court and went back on the court. So Steve or Jim may make other comments.
Jim?
I don't see any particular advantage to it or disadvantage other than the political factors Georgia has cited. Certainly someone who is on the court is familiar with its inner workings, which may enable the new Chief Justice to hit the ground running. In this case, Roberts was a law clerk for Rehnquist and does have some knowledge of the inner workings of the court. But that's not necessary. John Marshall, for example, often considered one of the great Chief Justices, had never been a judge anywhere.
Steve?
Yeah, I don't have anything extra to add there.
Okay. Good. Next question. Right here. Yes.
I was wondering, part of the historical look, Jim, at maybe why these confirmation battles have ramped up, in addition to what George had mentioned. When the court really got the power of judicial review, did that add to the consequence of these? Did that perhaps explain some of the increase in the contentiousness or the Senate taking an interest?
Repeat the question, sir.
The question is, when the court got the power of judicial review, did that increase the contentiousness of the nomination process? I think the power of judicial review was foreseen and intended by the framers. The court, of course, exercised the power by striking down an act of Congress only twice before the Civil War. So I wouldn't put it quite that way. I think the contentiousness of the process has been increased by the sheer number of contentious issues that are brought before the court in an increasingly litigious society, and by the increasing frequency with which the court exercises its power of judicial review in a controversial fashion, leading some to cheer and others to be horrified as what they regard as a judiciary very much overstepping its proper bounds.
And that has actually gone both ways. At one point in time, liberals have complained about it, and conservatives have complained about it. Steve, you had an initial comment?
Two thoughts. One, I mean, the number of nominees not confirmed actually is much smaller recently than in prior years. The all-time champion for having his Supreme Court nominees not approved was President John Tyler, who I'm sure you all know and love, who had 8 nominees not confirmed, but that was a period of time of absolute hardball politics where Tyler was of one political party, the Senate was another. Tyler kept saying, I nominate this person. They'd say, no, he's of your party, not of ours. Thumbs down. 8 straight times. So a lot of dynamics there, really unrelated to judicial review. The other thing I really wanted to echo Jim's thoughts. This is a topic of another discussion sometime, but increasingly we've looked to the courts to decide the toughest issues in society. Families don't do them anymore. Legislators don't. Churches and other institutions have defaulted on many, many issues to the courts, and those are all issues about which people believe very, very passionately. So it's not surprising that when passionate issues are in play and elected legislators and senators are representing those people and those passionate views, that the temperature goes up a little bit in the confirmation hearings.
Thank you. Next question. Yes.
We were talking about goals that presidents elect justices, and they have goals in mind. Do you have any thoughts on what President Bush's goal is for electing Roberts as Chief Justice?
The question was, what do you think that President Bush is trying to accomplish by nominating Roberts, not only for the court, but also for Chief Justice?
Well, I think clearly, as I said, confirmation is job one. I think there's no question about it, and I kind of suggested that a president does look at the political landscape. And if you remember, Roberts was recently nominated to fill Sandra Day O'Connor's seat. Then upon the untimely death, or maybe people would say not surprising death, of Chief Justice Rehnquist, then he was renominated for that position. And I think clearly that George Bush has made it quite clear that in earlier interviews that he would like to see justices in the ilk of Scalia and Thomas, indicating certainly he had ideological goals as well as confirmation. And also, I think I can say what he didn't have in mind. Right now, I don't think representation was a goal because he didn't choose to replace Sandra Day O'Connor with a woman. He chose Roberts. I think he was concerned maybe about also the goal of consensus because I think he's worried in the future he wants to make that court, as if you will, Steve talked about it, the Roberts court, and move it. And Roberts is known and is talked about in the papers to be, again, a very affable person. Now, you need people on the court to get you there ideologically, but you also need those social skills. And so I think that kind of plays in as well.
Very good. Next question. Way in the back, yes.
I didn't know if anyone had any predictions on who, since President Bush was going to nominate Roberts for Sandra Day O'Connor, and now it's his nomination for Chief Justice, if anybody had any predictions on who he may nominate in her place, or if not, if someone could speculate on the type of person who's looking for these Wralstad.
Well, earlier Steve said that we should not answer hypothetical questions if we are nominees, but we've been posed one here. Who do we think the President may nominate to now fill Justice Sandra Day O'Connor's spot? And
Well, if one of the things that President Bush is concerned about is keeping a second woman on the court, and I think that might well be a goal of his. There are a number of very accomplished women in the federal judiciary at the Court of Appeals level. Remember, the Supreme Court is the top court. There are federal courts of appeals. There are 13 of them across the country. Judge Wood from the Seventh Circuit, Judge Wagner from the Seventh Circuit are very, very capable women. There are, name escapes me, there are a couple of very capable women jurists in the Fourth Circuit and the Fifth Circuit. There may well be some on the various state Supreme Courts, which is Sandra Day O'Connor came from the Arizona State Supreme Court. So there are a lot there. President Bush and his family have shown a lot of affinity over the years for the Hispanic population, and so there are some very capable people there. I think either of those, if I had to guess, is what I would guess. So,
Georgia?
Well, two things that make me agree with Steve in a lot of ways, and in terms of the actual person. First of all, Sandra Day O'Connor specifically said she was disappointed when Judge Roberts was nominated to fill her slot. Also, Laura Bush has made it clear that she would like to see a woman on the court. There's also been some speculation with New Orleans, the hurricane, difficulties in opinion polls, all kinds of things. The name that's popped up a lot is Edith Brown Clement, who is a judge on the Fifth Circuit Court of Appeals out of New Orleans, as a potential nominee. She's fairly conservative, although not the most conservative. Whether or not she would turn out to be Bush's Sandra Day O'Connor, that moves a little bit in kind of a moderate direction after Reagan nominated Sandra Day O'Connor, is another thing. There might be a little battle from his base on the right. I agree with Steve that it could be Latino as well. The name that's come up is, of course, Attorney General Gonzalez a lot. He has some difficulties, again, because there's been some suggestion that he's pro-choice. He has openly said that he favors affirmative action. And he has memos suggesting that some of the how should we say this, incarceration techniques that went on at Guantanamo Bay were acceptable when people have criticized that. So I think he has some problems. Plus, Arlen Specter, if I recall, 2 days ago, suggested in a little hint to George W. Bush, don't nominate Gonzalez. We like him right here. When the chair of the Judiciary Committee says that, I think you got to listen. So they might be looking at Emilio Garza, who is also I think an appeals court judge out of, I think it's the Fifth Circuit, but it might be the Fourth Circuit. I can't remember. Maybe Steve can remember.
I thought it was out of the 11th Circuit.
Oh, I thought it was Fifth.
It might be.
Anyway,
they run together. The 11th and the 5th are right next to each other, so
anyway.
You may well be right.
Okay, thank you. Another question? Yes.
After President Bush had chosen made his choice for the Associate Justice, then he kind of had to shift gear to the Chief Justice. Is it better for him to try and, ram another choice in right now, or to wait a little bit and kind of see how things come out from his first choice?
It's a good question. Should President Bush attempt to get the second nominee in right away, or should he wait a little while and see how the hearing goes with Roberts? And the vote, for that matter, too.
Quick answer from the practicing attorney. I'd want him to move quickly, because when you have 8 justices on the Supreme Court, you have the risk of 4-4 decisions, and that's a disaster for everyone. Mm-hmm. No one knows what to make out of a 4-4. The historian, the political scientist may have a completely different view, but for me, that's awful. That's the worst possible situation for me to be in.
Jim?
Well, the other factor to consider is that O'Connor's resignation is effective upon the appointment of her successor.
Right.
She will presumably continue to serve on the court until her successor is confirmed. Now, if her successor is confirmed in the middle of the court's term, that raises the awkward question. Suppose O'Connor has participated in hearings on a landmark case, and her successor is confirmed before the court makes its decision. Does she participate in the decision? I don't know the answer to that one. From a purely political standpoint, my guess is that Bush will wait until the outcome of the Roberts nomination is known, and then make a nomination very rapidly thereafter to fulfill O'Connor's seat. But that's just a guess.
Georgia?
I generally concur with Jim as far as kind of political context goes. I think President Bush will wait until the Roberts nomination is sealed. It gives him the chance to see the lay of the land, and I think to kind of survey the questions and to survey the whole, as I said, number one goal, confirmation, to prevent which something he wouldn't want, which would be a political bloodbath. So I think he'll wait.
And he won't have to wait that long either.
No.
The hearings are a couple of days. The Senate will vote shortly after that. So this is not months and months he'll have to wait.
No. I believe that Roberts is scheduled to again be back tomorrow. If nothing goes wrong with that, then I believe there are a couple days with other individuals testing before or against him, interest groups or others. I think the vote is scheduled later on this month. He should be on the court by October 3rd. And that should give President Bush time to ramp up. Whether you can get that nominee confirmed before the first Monday in October is another question. I don't think it'll happen.
Remember, the first Monday in October is when the Supreme Court starts its term. So that's why the first Monday in October is a significant date.
Any other questions? Well, this event was brought to you by the American Democracy Project, the Mike Down Center for Indiana Politics, and IPFW. We want to thank the Helmke Library for allowing us to use this space, and College Cable Access Channel 56 for recording it and broadcasting it. And, of course, we want to thank all of you for showing up this evening. Thank you very much.
Thank you.